any professional service provider of any discipline and any domain of knowledge, the most important thing is the learning on the part of such service provider is always ongoing in nature. It is something fundamental. Every one of us, we must realize that. By getting a basic qualification, you may technically be allowed to render service. But when it comes to knowledge, it is something ongoing and lifelong in nature. There is an underlying premise for this particular proposition. That is, as the social life is dynamic in nature, as the time grows, as the various influencing factors change. For instance, for the last 10 to 15 years, the impact of technology in any professional discharge of function is something unbelievable. Take healthcare for instance. The kind of technological importance is something not many people really felt that it would be so immense in nature. Not only in the case of medical profession, I think cutting across various professions, the science and technology, something very, very fundamental. Similarly, as the impact of an external factor like a scientific process or a technological process is there, naturally various related issues, they crop up for the discussion and deliberation. For instance, yesterday our friend's question about removal of life support system is something to do with not only the professional conduct, but professional conduct premised under technological influence. As the technology grows, we are in a better position to prolong life. I think that's what is witnessed throughout the globe. I'm sure you are aware. The first world, if you look into, the people who are healthy, the number is increasing. As a result, geriatric population is multiplying. Because we are in a better position to provide quality life. As you grow, the 1960s, 1970s, 1980s experience of healthcare problems, I don't think the present generation, the generation who are above 60, above 70, they face. Because they are in a better position. Maybe numbers, they are debatable in nature. But otherwise, the impact is something. Which means, when these kind of influences are there, the service provider is under an obligation, please remember, to get to know about in what way the knowledge is going to influence his own practice or her own service provision. When we consider this particular ambit that a professional service provider is expected to take on, continue in terms of learning, knowledge gaining, one important thing is ethical conduct on the part of a service provider is something very, very ancient in terms of significance and origin. It is not just 2 or 3 decades ago people started talking about ethical accountability. Many people felt that irrespective of the nature of the service you provide, everyone is under an ethical obligation to be or not to be in a given contextual situation. To that effect, the premise, the foundation, as you were saying the day before yesterday, it is a moral principle only, even today. But a moral principle which is applied in different contexts. That's how the moral conduct of any service provider has assumed serious significance. In fact, to this effect, I just wanted to mention the influence which could be conflicting at times or complementing at times, that is law and ethics. I'll give an example. If the objective of a law or a legal prescription is to regulate the human conduct as and when the contingency arises, the so-called regulation of human conduct cannot be foolproof in nature. It is impossible. In fact, if you look into in India, many people say there is over legislation. There are too many laws, so much of law. It is almost impractical for an individual to get to know. Ignorance of law is no excuse, may not be practicable, because can you name even one person who knows all the laws applicable insofar as human conduct is concerned? Which means it is more of a metaphoric in nature. Ignorance is not an excuse, it is a metaphoric. We do not know whether it is practically sustainable or not. Why I am saying is, ethics in terms of the influence and premise is very, very insightful in nature. But the legal regulation cannot be. Ultimately, at the end of the day, please remember, law alone cannot succeed in controlling or regulating the human conduct. Impossible. That's where medical record documentation, you mentioned attitude. Why did you say that? At the end of the day, it is for the individual to think. You may have hazard laws, you may have so many restrictions, so much of enforcement. But I don't think it really reflects whether an individual is in a position to honor the kind of regulation or legal prescription. Therefore, many people since ancient times, they felt that appealing to the individual conscience is a better option. That is how ethical conduct has assumed crucial significance. As I told you, in various other parts of the world, ethical conduct is more a kind of appeal. It is better, it is desirable. You are being a professional, you do undertake these kind of things. But in India, when it comes to the code of medical ethics, etc., there is an overlapping, because the ethical conduct has been given a legal wrapper. That is, the parliament itself felt that no, it is, it can't be merely an appeal to the professional service provider, but it has to be in the form of a law. That's how the parliamentary intervention has come about. But otherwise, even now, in many countries, ethical obligations, they are considered to be an appeal. Accountability is there. It's not that it is without accountability. There is accountability, but the accountability process and formalities is not like a regular legal enforcement or legal accountability. I think to that effect, the fundamental premise, insofar as Indian context is concerned, slowly, because of various influences, various developments, people started realizing. Even for instance, when we talk about medical ethics, the phrase medical ethics, the conventional thinking merely confined to the practice ethics or clinical ethics. In other words, in a doctor-patient relationship, what a doctor is expected to do, in what way the protection of patient interest is to be taken, in what way he is entitled to protect or promote his own autonomy, etc. That's all. But now in the present day context, we realized it is not only in the context of a doctor-patient relationship. There are two other areas where there is a need for ethical clarity. One such area is research ethics. Research is not to be misconstrued or confused with the trial-based ethics. Research means it is more of a academic research, or a research where intellectual abilities are tested in terms of a particular study, which may give a kind of insight into advancement of science, or betterment of treatment, or better process of rendering service. All these aspects come under research. And accordingly, an individual, a doctor or a professor, or you name any person, there are certain processes, there are certain ethical obligations. For instance, publication ethics you take. This is one area in India, a lot of criticism, lot of debate is being. It is not only a kind of fictional writing, I am talking about research-based ethics. If at all you want to publish a paper, a research paper, the process, is it covered by ethical mandate? If so, what are the ethical obligations on the part of the author or authors? That's where comes into the essential copyright value. Copyright is not merely an intellectual property as such. Copyright has an ethical premise. Copyright has an ethical premise. The ethical premise is that an author, a researcher who wants to publish a particular research paper is under an obligation to follow certain ethical principles. Therefore, it is not merely doctor-patient relationship or clinical ethics or practice ethics. There is another ambit called research ethics. And thirdly, the most important and the significant development, what is happening in our country, and I am sure in other countries also a lot of importance that is given, owing to the kind of international relations, the political debate about, for instance, World Trade Organization. The entire paradigm shift in terms of relating intellectual property rights with the economic development of a sovereign country. People started realizing IP, that is intellectual property right, is not merely an academic activity or a principle of legal, litigation between two individuals. That is at a micro level. The broader, the overview, if you take note of, intellectual property rights have something, something great contribution towards economic development of a country. That's where World Trade Organization. I know that there is another side of argument for every process. I am not here to take sides, but at the same time to brief you how over a period of years we realize that intellectual property right assumes a serious significance. And as a result, the R&D, science and technology, we realize that of late tremendous strides that have been made. One such area which has become a very, very complex and commercial proposition, that is clinical trials. As a result, the entire process of drug experimentation has assumed a lot of significance. Not only an economic perspective, even a political perspective, but also science and technology, and also human rights perspective, technological perspective, and the ethical obligation on the part of the people who are testing or experimenting a particular drug on either a human being or an animal, a living being, doesn't matter. That's how the third important area which has received a lot of global attention is the clinical trial based ethics. Friends, the phrase medical ethics, as I told you, as a matter stand in India, Code of Medical Ethics 2002, which replaced the 1972 code, primarily, predominantly talks about doctor-patient relationship. That is the practice ethics or clinical ethics, predominantly. Maybe one or two provisions are there where they mention about endorsing ICMR regulations with regard to, that is ICMR ethical guidelines with regard to the human experimentation. In that way, indirectly they ratify whatever ICMR guidelines are there. Otherwise, Code of Medical Ethics 2002 is more attuned towards the individual doctor-patient relationship and accordingly the ethical obligations. For human experimentation, as I told you, the updated version of ICMR guidelines, they are more elaborate, more insightful, which they give lot of information as to how a drug trial is to be conducted, what is the role and responsibility of ethics committee, how it is to be composed, in what way the functioning is to take place, how and on what basis you give an approval or you reject an approval, whether you have a right to seek clarification or amendment or not. Various issues have been covered. Now, I am sure every one of you are aware, a comprehensive legislation pertaining to the clinical trial ethics is now initiated and it is pending before the ministry. They wanted to have whereby IEC now onwards has to be registered when the legislation comes into picture. And accordingly, IEC, the accountability they are going to predominantly mention. In addition, various stakeholders who are involved in the clinical trial or drug experimentation. Similarly, even with regard to research ethics, if you take note of, no doubt ICMR has constructively contributed towards that. However, a legal wrapper, if you take note of, it has not yet been identified. That is the reason why even today in India, I am sorry for my observation, please don't mistake me. Many people do not even consider the need for ethics when it comes to research. They think that it is for the individual or the guide or supervisor, institution, that's all, nothing else. I mean, very simple issue. whether a photograph of a patient is to be published in a research paper or not. I am saying now the days have changed. In good olden days, we were indifferent. Forget about ignorance. We were indifferent. No, there is no need for any such kind of thing. If at all you want to do it, you can do it. But stage has come now. All the people, they were made to realize it is just not in only in Indian context. Globally, the individual rights must be recognized and must be protected. Under no circumstances you can say, I am the researcher, you are the subservient, and I can do whatever on. No, under no circumstances. Just giving an example to drive home the point, medical ethics is not to be confined only to a kind of doctor-patient relationship oriented or something like that. All the three facets necessary and a legal recognition. I would even go to the extent of saying research ethics is not to be confined only to healthcare. I am sure research, it doesn't matter whichever discipline you are talking, there is a need for such kind of ethical conduct. Why only it should be confined to doctors? What about law people? What about engineering, management? Knowledge is knowledge. Everyone must be made accountable to. That objective principle must be recognized. If it is ethical, the focus is on the provider. If it is law, the focus is on the victim. That is the difference. In ethical consideration, please remember, a kind of appeal that is made to the individual. It doesn't matter whether the person will file a case, whether the person will seek a remedy. No, ethical conduct, please remember, even in Code of Medical Ethics 2002, that is the essential premise. It is an appeal to the individual. Come what may, you shall have to follow. Full stop. Okay? In law, the issue, as a lawyer, what we do? No, whether she understood, how did she come to know, what is the thing? You claim that it is yours, but we know that it is somebody else. Because there the entire focus is whether the person against whom the case is filed is sustainable or not. That is not the premise of ethical consideration. The premise of ethical consideration is, it doesn't matter whether there is a victimization or whether the person really feels victimized or not. Doesn't matter. As a professional service provider, this is what you are expected to abide by that. And you have to do that. I will give an example. In research ethics, the most crucial and most significant area is plagiarism. I mean, that's where copyright we discuss. Plagiarism. You lift the paragraphs, etc., and without acknowledging. There are several people who never even, they do not know that their work was copied. There is no commercial interest involved. I am not talking about the person who copied. I am talking about the source from where it was copied. The person will never come to know. No, here, or in some other case, the person from whose work it has been lifted, no, that's okay, he was doing MD, MS, no, that's okay, no problem. That is not acceptable.
It is unethical.
Absolutely.
But is there any clause?
That's what I am saying. When it comes to research ethics, it has not matured itself into legal enforcement. That is what I am saying. In the case of doctor-patient, I think you have it.
The person whose patient X-ray was taken by another professor was brought to the notice of the department head, say for instance. But can that be the basis for filing a case?
That's what I am saying. See, let me communicate one in a different manner. For instance, it's a very good question she has asked. Therefore, I am spending time. Let me put it this way. He is my doctor. Okay? I approached him. He said, you undergo these diagnostic tests. Okay? And he referred me to a particular lab. I went there, whatever scan, whatever that is required, etc. And I came back. He said, all the reports are quite normal, nothing to worry. You take these medicines and go. Okay? At the end of the week, the remittances take place. What kind of remittance? Every referred scan case, he charges 3,500, but he gets 1,500. What is it? A common practice, yeah. Unethical obligations are common. Because unethical obligations are practiced, they do not become ethical obligations. Okay? Now you tell me, I want to file a case against him. How do I do? What do I do? He got his check for 1,500. Did you receive it? Now I want to file a case. How can I file? Code of Medical Ethics 2002 specifically says whether you call a cut or a commission or a discount or a privilege or any word you use. In such circumstances, if the individual doctor receives anything other than what he deserves, for consultation you charge 100 rupees, no problem. But 1,500 for because he referred me to a particular lab. The Code of Medical Ethics says absolutely is professional misconduct. I can file a case against him before the Kerala Medical Council and accordingly whatever the proceedings will be. Okay? Now, one second. I don't think I have still clarified everything. You got the point? Here I could do it because Code of Medical Ethics 2002 is a parliamentary enacted legislation. You got the point? If the Code of Medical Ethics doesn't say so, there is no other law which says it is bad. That is the problem. In research ethics, please remember, I may have to really cull out a law of tort or common law principle, something, then we have to try. There is no statute, there is no codified law saying that if you indulge in plagiarism, this is the thing, that is the thing. Copyright law, that is there. I am not referring to the copyright aspect of it. You got the point? Or you have to acknowledge, or you have to take the permission from a particular person whose photograph you would want to publish. There is no statutory provision which explicitly deals with that situation. You got the point? That is where the distinction, legal recognition may not be there, but whatever guidelines we have now, they clearly say it is unethical. Therefore, it is not acceptable in nature.
Sir, we are talking of research ethics. When in usual course we treat a patient, we treat him, we look after him as a patient, we try to do our level best to take care of the patient. Suppose one of the finding is such that that can be published or that can go for research. At that time, these protocols of ethics and all these things are coming, and now we are abide by this, all these ethics and all. My question is totally different from research ethics. Just we want to know, I think my friends may know, I am not aware, whether there is any ethics in media ethics, what they are doing.
Correct. Absolutely. In fact, as I told you, in an intellectual exercise, please don't mistake me, do not misunderstand me. In an intellectual exercise, please remember, it is not whether the other profession is having such kind of obligation. No, definitely they have their own rules and regulations. Please remember, as like medical profession or legal profession, some people follow and many people do not follow. It is even for media also it is there.
They are also publishing.
That's what I am saying. See, it is not only, for your information you will be surprised, the people who publish, it is not just an individual I am referring to. A professional, like a columnist, for example, a journalist, for example, they are bound by media ethics. But the only thing is, I mean, many years ago, we were having a workshop for human rights for police people. Lot of interesting, Dr. N.R. Madhavan has initiated that process. I used to engage a lot of lectures for police, sub-inspectors, inspectors, constables. One day DGP, the Director General of Police, some kind of criticism he was referring. He said people are this, that, etc. Then he said, this young man, he is an IPS officer. Till he cleared IPS office, examination, he comes from the same society, with the society which every one of you belong. He joins police force. I don't know what happens. He acquires a different culture. He said, we need to understand that cultural influence. What is that? He is very educated. He is a brilliant student. He is a gold medalist. He comes from a society like yours. Everything is fine. But the moment he enters he is in a different world. Why I am saying is, whenever any kind of service, you need not only the focus on the provider, but the environment in which the providers render service. Many people, in fact in Ahmedabad, in one of the lectures, one doctor asked so innocently, he said, Professor Joga Rao, I receive all my discounts whenever I refer for diagnostic lab through checks. Is it okay? I didn't understand the question. I said, how does it matter whether it is a check or a cash or in an envelope or in your pocket? How does? No. There is a difference. Check means I am paying tax. I said, with all innocence and seriousness. You know why? The reason is, it is an acceptable practice among the practitioners. He is not one. Please remember, he is not one. There are many people who indulge in that. That is where they think that, no, this is an acceptable way. If it is check means much better. Because you are paying tax. I told him, Code of Medical Ethics does not discriminate about the modus of payment. Ethical obligation is to be understood in that letter and spirit. That's all. What I want to tell you is, whenever we talk in terms of the context, it is not only the individual, but the environment and the surroundings in which the professional discharge of functions take place. That is also very, very important. In that sense, I think whatever you said is very significant, and those people are also governed by their own ethical foundations.
Is there a law which tells us even to teach, or we have an interesting case and after discovery we want to present in a clinical meeting, so the house surgeons wants to learn, the new postgraduates want to learn. Correct. Is there ethics coming into this?
First thing is that there is no law. That is something everyone, there is a kind of deliberation that is taking place, indicating the need for a legal prescription. But otherwise, definitely it is a matter of ethical obligation. However, there are certain exceptions. I will just give a parallel to that. For instance, Indian Copyright Act you take. Copyright makes it very clear that what are the circumstances in which either a civil or a criminal infringement may take place, the grounds, etc. Please remember, for academic purpose, for private circulation, the material that is distributed with the proper acknowledgement of the source, origin, author, etc., that is not a violation. You get the point? I am just giving a parallel to say ethical obligation is where the kind of return or recognition which may get accrued to the author. Number one. Number two, where a public, it comes into public domain. These are the two significant factors. If you say that it is only for a classroom purpose, etc., definitely it is a valid exception, and it is not just for any, it is not only you as a professor. I am sure different academicians, they will be using that problem. Definitely there is no problem.
Explain to the patient, look here, is it okay if we kind of used you for XYZ purposes?
Correct.
And the patient should have the choice to decline.
Correct.
That ensures dignity.
To tell you very frankly, that's a very important point doctor mentioned. In fact, if I just look back and say, I am not judgmental, but many a time doctors themselves never felt the need for considering the patient viewpoint. That's the kind of focus. They felt, no, after all we are doing it for the purpose, whatever class, etc. Why should I do it? Or if it is a publication, it is nothing but advancement of science and technology. Why would I require to seek permission from the payer? That was but now people started realizing. Now I think that's where slowly we move from one paradigm to another paradigm, where the focus is not merely a public service or something, but the person whose information we are. I think to that effect there is definitely, maybe over a period of time we will be able to.
In our institute, we have we are collecting HIV specimens, and we ask the patient if it is okay for us to keep the specimens for a longer time, if it is okay.
Correct.
And if the patient declines, we do not
Definitely.
take that amount. So that's something very important. So it is very important to acknowledge that the individual has some rights, and that has to be done.
Absolutely.
So that
in
is
fact,
something that we
doctor,
should do.
I just add one footnote to what you have said, because you represent Nari.
That's right.
Okay, I know the kind of very effective processes that are kept in place. One footnote is that it doesn't matter what the other person wants to file a case, whether he requires a remedy. No, those things are immaterial. In ethical obligation, the focus is on the provider. If absolutely, that is the reason. For instance, whether a person will come to know whether the specimen, how do you identify, how do you relate it to an individual? It is not necessary. It is immaterial for the purpose of ethical discourse. Yeah.
Doctor, actually what is ideally preferred is that law and ethics should work together to facilitate research which is conducive to national interest.
Correct.
But what happens in a situation where there is a conflict? For example, research in the areas that are controversial may or may not be in the national interest, which should actually be thrown open to debate. But if he were to do it, the inventor actually runs the risk of bringing his invention into the public domain and thereby lose his right to a patent. How do we reconcile this conflict?
Yeah, in fact, even now I don't think there is any kind of clarity with regard to the issue what you have mentioned. But I am sure there are competing viewpoints as to in what way we can. I mean, the essential premise of your intervention is, should that be allowed to protect individual interest, or should that be allowed to make it for community interest? How do we do that? If you give a patent, what happens? Patent provides an exclusive marketing right, which means I will get monopoly over the returns, economic returns. For 5 years or 6 years or 7 years, nobody can do anything. I will be the person to do that. But suppose if it is in the common interest, community interest, should that be allowed? Should it not be given to the community? For instance, even with regard to WTO, the kind of document, the various provisions, if you look into, in the sector of pharmaceutical drugs, it is mentioned very clear that if the government, the sovereign authority feels that in the larger interest, this particular area not to be allowed, the government is entitled to do that. In fact, you will be surprised to know HIV, ART drugs, antiretroviral drugs, if you look into, many governments, many means 2 or 3, governments came forward where the private licenses have been suspended. Government has taken the responsibility of producing in a bulk way, because they can subsidize the price. If it is left to the private individual, they will not be able to do it. To that effect, with regard to pharma, I think there is definitely a clarity. But I am sure your question is much more generic and with regard to other aspects. To tell you very frankly, I don't think there is any kind of debate as of now, but I am sure slowly things will change. Definitely, if you ask my personal opinion, I think definitely there is a need. Because I personally feel any intervention which benefits the public at large, I think government must intervene and make it available to the public. But now it is kept under the carpet. Nobody, because everybody is interested, they wouldn't want to publish, because if it comes in public domain, the possibility of obtaining a patent is lost. Therefore, a lot of conflicting interests, etc. take place.
Sir,
Yeah.
just I have a question to you.
Yeah.
That we should, as a doctor or as a researcher, we should respect the rights of patients or volunteers, no doubt.
Correct.
But also we should take measures to bring awareness among them.
Correct.
Suppose, just as for example, suppose a patient, a very means illiterate patient having an ulcer comes to you,
Yeah.
and if you take a picture just before treatment, simply you take, if you don't ask anything, then I don't think it will be a problem, at least in our field, in Ayurvedic field. And after treatment you can take a picture. But if you ask that should I take your picture, then she or he may answer
Declare.
in that way No, not in that. Okay, when I will come in the next time, I will ask my husband or my daughter or brother,
Correct.
and then I will tell you.
Correct.
Then what is the use of it? Because already 7 days is passed or 15 days is passed, and I don't get the picture of that before treatment. This is the basic thing, because it depends on also educations of that participant also.
Correct.
This
I
is,
fully
think,
agree with you.
it
There
is practicable. It is practicable. I think.
No.
we
There is
should-
definitely a point in your question.
Yeah.
However, I do not agree.
Yes, sir. I
You
also don't agree. So I am telling
excellent.
that.
That is excellent.
So I am telling that awareness.
Correct.
Awareness among the participants should be promoted.
Absolutely.
Promoted by us.
To that effect, I don't have the debate. That's what her question also. See, the issue is, should there be or should it be or not? It should come in the public debate. It should not be confined only to the professionals or service providers. To that effect, I agree with you. However, whether the patient should be allowed to consult or not, I don't think ethical principle can be compromised on that. No. If the ethical principle requires such a consultation, such a consent, and I think we should take the consultation and do the thing. That's it. Yes.
Yeah, in case of this photograph, that's true that it's ethical to ask these people. But again, when we talk about this, my treatment and publication, there could be intervening years. In that case, even if the person gave the consent beforehand, by the time the doctor wants to publish it, that person might not agree again. So in that way, I think it's needed to take the permission of the person before you publish.
Correct. You are right.
And in that case,
there's no doubt about it.
His question regarding that one, that he can take the photograph, but if he wants to publish it later on, he can ask the person.
Correct.
Just like that, keeping a specimen for a particular purpose,
Correct.
we need a written consent for that.
Correct.
And it has to be stated that for what purpose he is keeping it there.
Correct.
If that person is going to use it for another purpose, like
Any other
analysis,
purpose,
then again,
Correct.
another
In
consent
fact,
should be
this is
needed.
very clearly written and made very explicit. In fact, I would say, whatever you are stating, please remember, all the options you have mentioned, they never compromise the ethical principle. At the same time, depending upon the context, you interpret and accordingly. To that effect, you have to take the person into confidence and consent is necessary.
There are people who apply for blanket permission.
Yeah.
Like, they collect the blood, but then they do the investigations, then they do the other genetic, this thing and all that analysis and all. Is it correct? I mean, is there a law or ethical this thing which would protect it?
Yeah. In fact, in some of the institutional ethics committee, these questions have come about. I personally gave my own opinion. I felt that there cannot be a blanket consent. Consent is always informed pertaining to the proposition that is made clear, pertaining to the purpose for which the specimen is being used.
So they can have multiple consent forms for each of the...
My insistence is not on forms.
Okay.
My insistence is on communication.
Yeah. Okay.
Content.
Yeah, informed.
What I want to tell you is,
Informed.
for example, our doctor from Manipur, just now he said, you just do that, but subsequently you want to do for some other purpose. Again, you have to take the consent. That is what is there. I mean, blanket, definitely it is not. It's not acceptable, and I think it is challengeable. Friends, I just would like to conclude by saying one appeal to every one of you. I request every one of you to read the Code of Medical Ethics 2002. Very, very important. If you read, you understand there are various specific situations which are covered by the professional conduct.